Hello and welcome back. GovDoc News. No opinions, just facts and summaries of government documents. You do the rest. Back at it with a Supreme Court order from October 14th, 2025 in the case Thomas v. Humboldt County. So here we have another denial of certiorari from the Supreme Court. So let's take a look what's going on under the hood with this one. Since 2017, Humboldt County has used a code enforcement program to address illegal cannabis cultivation on private properties. Under the county code, violations trigger a series of events. Daily fines starting at $6,000 per day for the first violation, escalating to $10,000 per day for ongoing issues. Abatement orders, requirements to remove plants, equipment, or even demolish structures that were used for cultivation. The administrative process is triggered. Property owners get a notice of violation and can request a hearing before a county hearing officer. The officer decides if a violation exists and sets penalties. There is no jury involved. It is an internal county process. No jury involved. Remember that. Fines often apply even if violations occurred under previous owners, and notices are sometimes vague, inaccurate, or based on outdated information. And this leads us to Corinne Morgan Thomas and Doug Thomas, a retired couple who lost their Los Angeles home to wildfires in 2020. After that, they bought a 5-acre property in Humboldt County in 2021. Unbeknownst to them, the previous owner had used a barn for cannabis cultivation without permits. The county then demanded the Thomases demolish the barn and pay escalating fines despite the Thomases' lack of involvement. There are also other plaintiffs in the case with similar stories, but we are just choosing the Thomases as the lead example. These plaintiffs are accusing the county of running a, quote, dragnet system that issues notices without solid evidence, delays hearings, and imposes penalties to extract money rather than fix actual problems. So, there are 4 major legal claims we are talking about with this one. 8th Amendment, claiming the fines and fees are grossly punitive, vague, and disproportionate. 14th Amendment, claiming the process is arbitrary with vague notices, delays in hearings, and biased hearing officers. 5th Amendment, claiming the demolition orders amount to uncompensated property seizures. And the 7th Amendment, claiming that the county hearings deny a jury trial for civil penalties, treating them like administrative matters. Important for us to remember here is that with the 7th Amendment claim, they were asking the court to overturn a 1916 Supreme Court precedent known as Bombalis that says the 7th Amendment's right to a jury trial does not apply to civil cases at the state level. So, to the courts. The U.S. District Court for the Northern District of California dismissed most claims for lack of standing or failure to state a claim. In the appeal to the Ninth Circuit Court of Appeals, the 8th Amendment claim was revived with the court saying the fines could be punitive. Also, the 14th Amendment due process claim was revived with the court saying the process could be arbitrary and unreasonable. However, the 7th Amendment claim related to the right to a jury trial was still dismissed, and the 7th Amendment issue is what the appeal to the Supreme Court is based on. And here we are seeing the Supreme Court denying to hear the case to decide whether it is constitutional that there are no jury trials for civil cases on the state level. For now, the case is back in the Northern District of California to decide the claims that were revived by the Ninth Circuit Court of Appeals, and that is where we stand today. All right, Kaimo, keep your mind open, do your own research, form your own opinion. See you next time.